much for attending this Sajika Final Conference. My name is Chiara Scissa, and I will be the chair of this second section called Determination 1, which deals with some relevant SOGI-related issues arising during the evaluation process of an international protection request. I immediately leave the floor to Alan Bredek. Alan Bredek is a barrister specializing in immigration and asylum law with a particular interest in LGBTQI+ cases. Bredek has represented many dozens of LGBT refugees at all levels of court. They are a former trustee of the UK LGIG and the author of The Recognition of Refugees Based on Sexual Orientation and Gender Identity in the UK, an overview of law and procedure, published by the Birkbeck Law Review. They are also a co-founder of the trans rights group Trans Equality Legal Initiative. Today, Alan will introduce us their paper with the title LGBT Claimants Denied Refugee Status Due to Multilayer Marginalization. Please, Alan, the floor is yours.
Thank you, Chiara. I'm just going to try and share my screen, and hopefully this will work for a PowerPoint.
Let's try that.
Okay. Right.
Perfect.
That seemed to have worked. So thank you, Sajika, for having me. I've got 15 minutes just to cover this quite broad topic. So I just want to really touch on it just to illustrate some of the difficulties. But effectively what I'm going to talk about is the way in which LGBTQI refugees are marginalized and how that can lead, unfortunately, to their claims being refused. Now, as mentioned earlier on in the keynote address, the very fact that someone is from a country where there is persecution on the basis of someone's SOGI is marginalization enough, but unfortunately that's amplified when the person gets to the purported safe country. Obviously, not obviously, but I'm going to cover it from the UK perspective, but which is where I'm based. But I think these principles apply across the European Union. I noted in the keynote address that it was said that a trans woman was refused refugee status in Germany because she presented as male in her journey from Syria. So that's the type of thing that, that I'm referring to. So just right. Okay, so just very, very briefly, in the UK, and this is a similar test I know in other European countries, in the HJ Iran case was really 2010, which was a case that first really allowed LGBTQI refugees to claim asylum successfully in the UK. And the Supreme Court set out this 4-stage test. And I just want you to draw attention to that quite briefly. So is the person LGBTQI? Proving sexuality, which is a very contentious issue. If the person lived openly in their country of origin, would they face persecution? Would they actually live openly? And if they didn't, why not? And the law is that if they simply concealed simply because that is how himself would wish to live, then the person's not a refugee. So I want to concentrate on those first two parts of the test, which is where the multi-layered marginalization can lead to the individual's claim being refused. Looking at the test, in addition, of course, to the fundamental issue of, by definition, a person having to conceal their SOGI because they're fleeing a country of origin, which of course makes it, in most cases, that person may not be as open, whatever that means, than other people. But as I say, that puts the person at a disadvantage. In stage 1, which is proving their SOGI, and at stage 4, requiring to show that it's a material reason that they would conceal their SOGI in their country of origin is due to fear of harm and not just due to personal reasons. I've always struggled to understand, could there ever be a case where a person where there is a well-founded fear of persecution in the country of origin would not conceal just because of, because of harm, as well as maybe personal reasons. But unfortunately, that's what the law is in the UK at the moment. So looking at the first point there, proving SOGI. So what the UK government expects, and I know similar expectations in countries around Europe as well, is in a sexuality case, they look for relationships. In a gender identity case, they look for some kind of transitioning. And that's very basic. When they look for transitioning, they expect the person to present as the in the gender that the person is in a very advanced way, but that might not necessarily be the case, as we heard about that case in Germany. They'll often expect evidence from partners, friends, family, attendance at LGBTQI bars, groups, events, etc. And then there's quite a large emphasis placed on realization of sexual orientation, gender identity, and journey. So in a sexuality case, they will ask, when did you first realize you were attracted to women or to men, etc.? How did you feel? How did that make you feel in relation to your religion, etc., etc.? And then unfortunately, if the person doesn't conform to all these stereotypes, so the stereotypes of a gay man having, for example, having lots of relationships, or being very active in bars and clubs and going out, having lots of friends, being very, very open, and then perhaps not presenting some kind of a narrative about realization and journey, then that person is in danger of being refused on the basis that they're not actually LGBTQI. The fourth part of the test, I'm going to concentrate on concealment for own reasons. So that is very much the concentration, even though the UK guidance is actually quite good on this, but in reality, both at the government decision level making and also on appeals on the judiciary, there's an incorrect concentration on how does the person act, in inverted commas, in the UK. Are they open about their soji? And as I say here, what does open mean? There's no real definition of that. Is open telling every single person that you meet, or is it having a relationship that you keep private because you're a private person? And we don't know what that word open actually means. I just want to have a quick look, just to show how this is being applied in the UK courts. In the UK, for those that don't know, there's something called country guidance cases, which, as the name suggests, are guidance for decision makers and lower levels of tribunal to use. And here are just some examples of how this is being applied. So this is obviously a Jamaican case, lesbians. And here, lesbians are not at risk because some are naturally discreet. They have children and are willing to present a heterosexual narrative for family or society reasons, and therefore there isn't a fear of persecution. Now, the mind boggles about how the tribunal came to that conclusion, and if they're willing to hide their sexuality in a country where lesbians are persecuted if they're open, I don't really understand the logic of that. Likewise, Sri Lankan case, gay men, risk, and the tribunal placed a lot of weight on the fact that those particular appellants kept, in their tribunal's words, a low profile in terms of their sexuality. They chose to live discreetly because they didn't want to distress or embarrass their parents or their friends. And one of the most troubling country guidance cases is an Algerian case. I had to delete quite a few slides from this presentation because I had too many. This is really one of the most dreadful determinations there are. But looking at this particular issue, if you look at this, where a gay man remains living with his family, who he has disclosed his sexual orientation, and they're prepared to tolerate that, his decision to live discreetly, to conceal homosexuality outside the family, is not taken to avoid persecution, but to avoid shame or disrespect brought on the family. So that's just just quickly here, also OO. This means that he's chosen to live discreetly, not to avoid persecution, and that gives rise to international protection. So just then looking at some cases where an individual has had their claims refused because of being marginalized. Now, these are real cases in the first tier tribunal. So looking at this first one, determination of a Ugandan lesbian, it was accepted that she is a lesbian, but her case was refused on the fourth part of that test. And this is what the first tier tribunal judge found, that she doesn't live openly in the UK, and therefore she would choose to live, to conceal her sexuality in Uganda, not from any fear of persecution, because that's how she chooses to live in the UK. Again, wrong application of the test and even policy. And then looking, therefore, at why that happened to her. So why was her case refused on the basis of multi-layered marginalization? So first of all, she's gay, she's a lesbian. That marginalizes her from society to start with. She's a woman, which also places her at a disadvantage in some respects. That particular person was Black. She was without status in the UK and therefore had no access to jobs, benefits. She lived by necessity in the Ugandan community and was afraid to reveal her sexuality. And all of those things meant that she was a refugee. All of those things led to her being very, very private about her sexuality in the UK. She didn't conceal it. She was just private. She didn't tell many people. She didn't go to bars. She didn't really have many friends. She was a very vulnerable, marginalized person. And because of that, she was refused refugee status because she was marginalized. If she didn't have some of those marginalization factors, then maybe she would have had some friends who she could have said, I'm open with, or a girlfriend, etc. But yeah, her claim refused because of those marginalization factors. Looking at a Jamaican gay man, again, another real case, brought to the UK as a child by his mother. Mother suspected he was gay and didn't like it, criticized him for not being manly enough, threw him out at age 16 and lived with foster parents. And again, looking at his marginalization, he's gay, he was also Black, he had no legal status in the UK at that stage. His mother had rejected him for not conforming to her idea of masculinity. He was in foster care and he had to fend for himself at a very young age. And again, he was refused on the basis that he would conceal his sexuality for his own reasons, because again, he was very vulnerable, he was insular, and he was private. Some people are private, and that led to this finding. His delay in claiming asylum very much ties in with the evidence before me that he's an extremely private person, loathed to discuss and publicize his private affairs and reticent about disclosing his sexuality. So again, all those levels of marginalization led his claim to being refused. Thankfully, both of those cases were overturned on the upper tribunal, and both were granted refugee status, but not after quite a long fight. There's an expectation, as I said at the beginning, that the person should be out and proud, as I say here. Again, this is from the Jamaican gay man case. I find nothing in the evidence before me to point to the involvement in the LGBT community, as if every single gay man or gay woman or transgender person has to be involved in the LGBT community, going to pubs, etc., making friends. That just wasn't him. Not everyone is like that, regardless of their sexuality. And then the second quote there, the evidence demonstrated that the appellant had chosen to live a discreet life here and conduct his affairs with discretion and privacy. And therefore, that is what he would do in Jamaica. So really quite an extraordinary finding to come to. And then looking at a case where an individual was and there are so many examples of this, but where an individual is not accepted as LGBTQI because of the multi-layered marginalization. And this is an example. So a Pakistani gay man, not gay enough. That's effectively what the tribunal found. So if we look at the brief facts of this case, he was married to a woman, obviously in Pakistan, because Pakistan doesn't have same-sex marriage. He only came out as gay in his 30s after he was married, obviously. He really struggled with his sexuality. He suffered from depression and had an addiction to alcohol, unfortunately. So looking at his multi-layered marginalization, he's gay, he's a person of color, he was rejected by his family, no legal status, suffers from depression, alcoholic, and of course, no money, etc. There's many others that we can look at. And because of all of that, the tribunal came to this conclusion. My conclusion for all of this is that he's a naturally reserved person. He is not needlessly open about his sexuality, whatever that, and will only reveal it to people and places who he feels at home and supported, such as gay nightclubs and on one occasion London Pride. But the tribunal went even further on that occasion, actually just slipping. Oh, I went one slide too far, and now I can't go back. But anyway, again, he was effectively judged on the basis that he had all those multi-layered marginalizations, and again, his claim was refused on the basis of that. So there are my slides. I think I've done quite well. I've got 56 seconds left as far as I can see. I just want to clear this, by the way, with Moira, Chiara, but a colleague of mine from Goldsmith Chambers, Catherine Jacris, and I are going to turn this into a paper and submit it to the International Journal for Refugee Law. And if there is anyone on this Zoom call who is a refugee and feels that their claim was affected by marginalization, we'd be really, really happy to hear from you to discuss those issues with you. Anyway, thank you very much.
Thank you very much to you, Alan. It was a very outstanding presentation. And the only thing I can say is that privacy is not a crime, according to me. So I was really struck by your presentation. Thank you very much.
Thank you, and exactly. Some people are private, whatever their sexuality or gender identity.
Then our next speaker is Aisha Uzun, who will discuss with us her paper with the title, "What is the impact of international national law on LGBTQI+ Syrian refugees in Turkey?" Aisha Uzun graduated in 2012 from Istanbul University with a BA and completed an LLM at HKU. Currently in the thesis semester at Istanbul Bilgi University, Cultural Studies MA, and a lawyer in the NGO supporting LGBTQI+ asylum seekers in Istanbul. Please, Aisha, the floor is yours.
Thank you, Chiara. I just need to share my presentation, and I think it works now.
Yes, it worked.
Okay.
Go ahead.
Thank you very much. Syrian LGBTI+ refugees have been fleeing to Turkey since a long time, and this number have increased since the Syria war began. My speech mostly focused after 2014, when the Temporary Protection Directive was adopted for people who flee from Syria to Turkey. And I will mention about legislative system in Turkey and my observation from field, as I have been working in the NGO to provide legal counseling for LGBTI+ refugees. I also put some quotes from applicants that were used in my previous research by following ethical rules. And Turkey is one of the first countries that signed the 1951 Geneva Convention with a geographic restriction that it maintains until today. And refugee status is only applicable for people coming from Europe to Turkey due to this limitation. I will be using refugee as term for people who are under temporary protection, actually. Syrian refugees issue was trying to be managed without adopting a legislative guideline by the major right-wing party, GDP. And then LFIP, Law on Foreigners and International Protection, was adopted by the Turkish Parliament on April 4, 2013. And this law brought comprehensive legal framework in terms of asylum law, and Temporary Protection Directive also is based on this law. And this directive provides also comprehensive rights to people who are under temporary protection, such as access to health service or legal aid services freely. And DGMM and PDMM was then established under the Ministry of Interior with the mandate of determining the status of asylum seekers. And the status of temporary protection actually makes the process of gaining status easier, since fleeing from Syria is the only requirement to be under protection. On the other hand, Syrians still face challenges during the registration process. And I put the EU-Turkey deal in the slide, and there is also impact of this deal in the legislative system. And this deal was signed to stop the uncontrolled arrival of people in the Eastern Mediterranean. And also the emergency degree law has an important impact on the legislative system, as this law has changed the principle of the non-refoulement. I will mention about that in other slides. And so I can say that the asylum procedure system was constitute between the EU asylum system and also the country's dominant policy system in Turkey. I would like to mention about the temporary protection by referring the ideas of applicant, as he explains very well the effect of protection, temporary protection on his life. I'm under temporary protection in Turkey. That makes me nervous, as it is always on unstable ground. Turkey government can say that temporary protection is cancelled and all Syrians will leave. Being under temporary protection makes me unsafe. I want to go somewhere where there's an actual law saying that you can obtain citizenship as a Syrian, or that you can receive a long residence permit. That will be clearer than temporary protection. I have been living and working in Istanbul for 5 years, and my status is still temporary protection. If I get a good opportunity to settle down permanently in another place, I will leave Istanbul. Actually, according to temporary protection, people who is under this protection have to live in where they were registered, and they have to live in this city to reach the service and have written rights. And they cannot leave the city without having permission from PDMF. And another important point of this protection, people do not have to prove the risk of persecution in their country of origin due to being membership of social group, as it happens in EU country, which is also so problematic, as Ellen also mentioned. And I would like to mention about a little bit the general perspective of national law, as there is no regulation in Turkey national law system regarding LGBT+ rights or SOGI. And even though Turkey signed and ratified the Istanbul Convention, still the patriarchal norms within the legal structure have never been abandoned. And according to actual Turkish constitutional law, international agreements are stronger than national law. And if there is a dilemma between this regulation, Turkey has to regulate its national law in accordance international agreement. And but still, in general, LGBT+ rights or SOGI have not been adopted in both legislative and policy levels so far. So unfortunately, we can say that LGBT+ have never accepted as living person under these circumstances in Turkey. And yeah, these are, I want to mention about also hatred against of LGBT+ migrants, refugees in Turkey. This structure in the legislation, such as public morality, obscenity, and the Turkish family structure, are used to prevent LGBT+ from having basic human rights. And the hate crimes against LGBT+ is the highest number on the data of NGOs, but still there is no active combat against homophobic, transphobic, and racist hate speech of politicians against LGBT+ refugees. And I also put a quote from the one of the from the Directorate of Religious Affairs. He gave a hate speech against LGBT+ rights during the Friday sermon. And there are multiple reasons to approach the administrative court in Turkey. And I would like to underline the application against deportation order, as it has increased after emergency decree that I mentioned in previous slide. According to non-refoulement principle, Syrians who are under temporary protection couldn't be deported in theory. But after adaptation of the degree law, a person can be deported if they fall under any of 3 categories. The most common of these categories is that posing a threat to public order, public security, or public health. And these amendments became the reason for arbitrary detention for Syrians. And also in the detention center, unfortunately, people were forced to sign voluntary repatriation without waiting the decision of court, and the authorities tried to make this arbitrary detention legal. And also there's a good example, because due to the collaboration between NGOs and Istanbul Bar Association, especially in Istanbul, application against deportation order has conducted immediately. And so most of the detention order was rejected by the court after the lawyers approached the Court of Peace. I would like to share one example. As an example is about Syrian trans woman who was under temporary protection. She was sent to the deportation center due to being charged with forgery. And then the applicants was sent to the deportation center in Kilis, which is close to the Turkey-Syria border. Then the lawyer appealed to the Constitutional Court without having a notification of the deportation order. And because she was sent to the Kilis, and this is so close to Syrian border, which means that she will be deported certainly. Then the applicant was forced to sign voluntary repatriation in the detention center and was sent to the Syria, even though she was threatened to death by her family due to her sexual identity. In this case, we couldn't appeal to European Court of Human Rights due to lack of approval from applicants, and unfortunately, we lost our communication with them, which made it impossible to obtain their approval. And there's no application on behalf of LGBTI refugees to the Constitutional Court, also European Court of Human Rights, except interim measure regarding deportation order, which is so problematic in terms of human rights advocacy. And I would like to share one of the quote from the participant, and he shared actually his idea about what he thinks about the LGBTI plus rights in Turkey. And he mentioned in this quote that actually LGBTI rights exist only on the paper in here, while the government banned pride if LGBTI rights exist. I'm living to leave the country as much as I love the country. If there is need to escape from the police rather than asking for support, how can I expect anything from this country? And also this quote shows that actually LGBTI plus refugees do not trust legislative system in Turkey, so they do not, in some cases, they do not want to approach the court. And the registration process in Turkey, actually, as I said, the status of temporary protection makes the process of gaining status easier, since fleeing from Syria is the only requirement. But still they face some challenges during the registration process. They have been assaulted verbally or physically by Syrian community or sometimes authorities in PDMM, and once they find out their SOGI. And despite these challenges in PDMM, there are no regulations to combat these homophobic, transphobic behaviors. And I share one quote also from the applicants who faced the intersectional discrimination in the PDMM. Yeah, there are many problems actually that exist in Turkey, and the LGBT plus refugees face intersectional discrimination also to find employment, since they are Syrian and LGBT plus, and most of them experience a hostile atmosphere on the job. Even though they try to hide their SOGI, they cannot stand this behavior or discourse after a while. Also, this precarious work makes their financial situation unstable, even though temporary protection provides work permission on paper, but in practice, it doesn't work like that. And in Turkey, there's no such facility to provide free accommodation for refugees as social right. Only NGOs provide this facility to their applicant if their baggage is enough. So applicants believe that also there is no any efficient legislative system in favor of rights. And support mechanism, the national government has never had any topic in its agenda. On the contrary, the first aim of the government in its policy regarding support mechanism is for heterosexual nuclear family. And NGOs have a baggage problem to support the applicants in a broad and effective way, but still there are good examples, and such as the Key Refugee Group project. This project, which is supported by the UNHCR and UNFPA, which the participant of the national NGOs. And the aim of this project is to create a more efficient support mechanism for key groups, LGBT refugees, sex worker refugees, and refugees who live with HIV positive. And the group organized a monthly meeting to discuss action to find more effective way. This collaboration proves that solidarity between NGOs. That's why I want to share this project with you as a good example. And the impact of national law and on LGBT Syrian refugees, actually the process of becoming European for Turkey and its obligation in terms of human rights policy do not render Turkey a safe country for LGBT plus refugees. And all legislative system of Turkey is based on heteronormative categories, and Turkish migration law is also part of this legislative system that doesn't provide any protection based on SOGI. And due to this ineffective legislative system and the ongoing ambiguity of their legal status, most of the LGBT plus refugees are willing to leave the country. So the resettlement process in Turkey seems to be the necessary solution for LGBT plus refugees under these circumstances. And Syrian LGBT plus refugees are invisible in this migration policy and legislative system. The only current policy regarding Syrian LGBT refugees, asylum seekers, and migrants is the resettlement process due to the exclusive government policies and relevant regulation regarding SOGI in the legislative system, and specifically Temporary Protection Directive. There are different dimensions of being LGBT refugees that are influenced by gender, sexuality, race, ethnicity, and class under the legislative system and migration policy of the government. And being a refugee, asylum seeker, and migrants give them a precarious state due to the Temporary Protection Directive system. And the discourse of politicians discriminates against LGBT plus and often refers to morality to reproduce hateful discourses, and that frame LGBT persons as non-conforming people. And NGOs are the only places where LGBT plus migrants can express themselves freely, but yet the capacity and power of the NGOs are not enough to provide more efficient facilities for individuals. And human rights advocacy on behalf of the LGBT plus rights are not efficient due to the multiple reasons. One of these reasons is the overwork of NGOs due to the demands of donors and lack of solidarity between the national NGOs in terms of human rights advocacy due to the neoliberal system's effect on NGOs and political conjecture. So in the end, the migration policy and the legislative system should consider multiple discrimination and find a way to implement strategies, and it requires solidarity, capacity, and cooperation with other groups. Thank you for your attention.
Thank you very much, Aisha. This was an outstanding presentation. Thank you very much, because it gave a precise overview of, well, an ambiguous country as Turkey is in relation to LGBTQI plus issues. And I think that an efficacious resume of what you have just said is that the Rainbow Map of 2020 said that Turkey just respect 5% of all human rights of LGBT people. So I think it's a small percentage of human rights to be respected, of course.
Yeah.
I ask you to stop sharing the screen.
Of course.
Thank you very much.
You're welcome.
And I would like to remind all attendees that if you have some questions or comments for our panelists, you can type them down in the question and answer chat box. So right now I'm going to introduce our last but not least speakers. Our last presentation focuses on SOGI-related asylum claims in Greece and the legal implications arising from the specific protection needs of LGBTI persons. This very interesting topic is presented by Maria Bazdeki and Dr. Zafiris Tsiptsis. So Maria Bazdeki is a lawyer currently working for NGO Solidarity Now in Greece. She provides legal assistance to vulnerable persons, among whom a significant number of LGBTQI asylum seekers. The past year, she also collaborated with IRC's refugee.info web platform team, as a legal counselor. Dr. Zafiris Tsiptsis is currently working for Thompson Solicitors as legal executive. He has a solid background in human rights law, international law, and humanitarian protection. He has a high interest in SOGI-related human rights, refugee rights, and other contemporary challenges in international human rights law and practice. So please, Maria and Zafiris, the floor is yours.
Thank you, Chiara. Thank you, Aisha, by the way, for the last minute switch. I will now try to share my screen. Just a moment, please. Okay, it should be fine, right?
Yes, it is. Please go ahead.
Okay. So thank you for having us here. Now, in the following 15 minutes, we are taking the opportunity to talk to you about the way the Greek asylum authorities deal with SOGI-related asylum applications. The purpose of this presentation is to highlight the problematic points throughout the examination procedure of SOGI-based asylum applications and to offer suggestions for improving the existing framework.
So here we present you the existing legal framework that the applicant may rely on in order to complete his asylum application. And apart from the basic legal framework, which is the Geneva Conventions and the EU directive, we attached as well the 2 cases from the Court of Justice from the European Union that are directly applied for SOGI-related asylum claims.
We are now going to comment on the generally inefficient framework for applicants with SOGI claims in Greece. So even though SOGI asylum applicants fall into the category of applicants in need of special procedural guarantees according to the EU directive, in practice there are many protection gaps. First of all, we do not have a comprehensive picture of the SOGI asylum applications submitted before the Greek authorities, as there are no official data published by the Asylum Service. Furthermore, the applicants who arrive either in the Greek islands or in the mainland have very limited access to basic information regarding their rights and limited access also to legal representation in the first instance. We will move on to the next significant point of concern, that is the introduction of a national list of safe countries of origin. Why would this be a problem? We consider this as a problem because when an asylum applicant comes from a country that is considered as safe by the Greek state, then the asylum authorities have the right to skip the personal interview of the applicant and to reject the application as inadmissible. In this list, we have countries such as Morocco, Tunisia, Algeria, Senegal, Togo, and Ghana. The same countries, as we can see in this map, are also included in the list of countries that criminalize LGBT activities on a national level.
So the asylum application process in Greece starts with the first registration process, which is the process are taking place at the reception centers and is conducted by the caseworkers most of the times. And it is the stage that where the caseworkers are collected all the personal data from the applicants and name, family name, and the reasons that they are going to seek international protection. And at this point, the applicants are able to express their interest to seek international protection on the grounds of their SOGI background. However, because of the circumstances under which the first registration process is taking place by the caseworkers, most of the applicants are not expressing their interest to establish their asylum claim based on their sexual orientation. The reason is that, first of all, because the caseworkers are not very familiar with the LGBT matters, or because they are not very familiar with the background, the religious background of the applicants, so they do not have any concerns about being an LGBT from these countries is an issue to seek international protection. So that's why they don't ask it most of the times during the first registration process. And also, if the applicant his SOGI background at the first registration process, the late disclosure from the Greek authorities, it's going to be assessed negatively, and it's going to be, and the application for the asylum would be rejected, which is something that it's not taking place in other European countries like Sweden, let's say. And also, another significant problem is that the caseworkers, from the caseworkers' perspective, they operate in an unstable working environment. It means that they are working under fixed-term contracts, so they don't know when these contracts are going to be renewed. And in combination with the lack of efficient training, and also that they do have to deliver up to 10 or 15 registration forms per day, they don't pay any more attention on the really grounds, that the applicants are seeking international protection, rather than completing the forms and submit them for the next stage of the asylum process.
We will now move to the following stage of the asylum procedure, that is the first instance personal interview of the applicant. We think that this is the most important stage of the asylum procedure before the Greek authorities, because this is when the applicant is given the opportunity to fully support and develop the reasons why he or she left their country of origin, and why they are now seeking international protection from the Greek authorities. In theory, this procedure is supposed to be secured with many guarantees, but in practice, things seem to be different. In the following slides, we will go through examples of SOGI-based asylum applications that were examined and rejected by the Greek authorities. In the first slide, we are mentioning two cases of SOGI-based asylum applications where the expression of sexual orientation in a later age led to the rejection of the applicant. Here, as follows, we also have examples where caseworkers argue the credibility of the applicant due to the way that the applicant chooses to express his sexual orientation. For instance, an asylum applicant was rejected because he preferred to lead a monogamous way of life, and this was considered as bizarre by the authorities. As we continue, we have a case where the authorities urge the applicant to return to his country of origin and to conceal his diversity as a way for him to stay safe and not to face persecution. And finally, this is a typical case where the questions of the caseworker are based on stereotypical behaviors. The applicant was rejected because he had never visited a gay bar in his country of origin. We still don't know if there are any gay bars in the applicant's country of origin, by the way. As a conclusion, we would say that questions based on stereotypical behaviors enhance the already existing cultural gap between the asylum seeker and the caseworker. For instance, if the caseworker does not take into consideration the country of origin information and the religious and societal background of the applicant, and at the same time makes the conclusions based on a more westernized way of thinking, we would conclude that this is most possibly a mishandled case.
But apart from the caseworker side of the things, that they are not, that they lack of efficient and sufficient training with regards to LGBT matters, another important point is that the same issue, it's coming along with the interpretation as well. So during the time of the first registration interview, most of the applicants are not feeling very comfortable to express their interest to establish a SOGI-related asylum claim because the interpreter could be a male. And also in most of the times, because of this first registration interview is taking place within containers, so we do not have the required confidentiality. Again, the applicants are not expressing this interest, and also because they do have we do not have enough interpreters at the reception centers. Some other members of the reception center is assisting with the interpretation. So again, the applicants are not feeling very comfortable to do this expression at the time of the interview. And on the other side, from the interpreter side most of the interpreters are feeling very embarrassed in order to translate terminology or SOGI-related experiences at the time of the interviews. That's why they don't assist the applicants in order to establish their claim for international protection on SOGI grounds.
So now, after providing you with a general overview of the problematic points throughout the asylum procedure until the first instance personal interview, we hereby suggest solutions for improving the existing framework. First of all, of course, we consider that training and education is very important. We would suggest the creation of a checklist of obligatory trainings to be conducted by various stakeholders on a regular basis, and of course for the whole personnel, for both caseworkers and for interpreters.
And also by giving an efficient and sufficient training for caseworkers, it will assist them to identify easier the applicants in need of special procedure guarantees as soon as they can. So this process wouldn't been taking place with any further delays. And apart from this, with regards to the asylum claims examination process, the states, it's much better to publish, the asylum services should be published much more instructions with regards to SOGI-based claims. This is something that the UK is doing at the moment, not only for the further training and information for caseworkers and interpreter, but also for the sake of transparency as well.
Now, regarding the internal issues of the asylum authorities, as we also mentioned earlier, it is vital for the high quality outcome of the asylum examination to provide all the employees, both caseworkers and interpreters, with a more stable working status. And talking on quality, we suggest that the official statistics of SOGI asylum applications submitted before the Greek authorities to be published. Also, regarding the training and the quality department of the Asylum Service, we suggest that it conducts quality checks on a larger sample of the interviews and the first instance decisions, and also that it includes EASO interviews and decisions as well. Now these suggestions are a bit more ambitious, but we are proposing them. As a legal reform, we would suggest the amendment of the recast directive to also include the free legal assistance and representation in first instance procedures.
And also that the list that Mary presented you before about the safe countries of origin, this list should be amended with regards to SOGI-related asylum claims only. And thank you very much for your attention today.
Thank you very much.
Thank you very much for your intervention. It was really precise and detailed, and it revealed also that there are national similarities among the domestic law that we have examined today. So UK, Turkey, and Greece. So we have an absence of empathy, of sensitivity, by domestic law, and also a lack of tolerance among native communities that lead to what Ellen named multi-layer marginalization and discrimination. So thank you very much to all our speakers today.